Next case on the docket is NERO and SKUTT versus Continental Country Club.
Good morning, Your Honors. May it please the Court, I'd like to reserve 5 minutes for rebuttal. My name is Paul Dehart. I have the privilege of representing the appellants in the case, GAIL, SKUTT, and Russell NERO. I'd like the Court, Your Honors, to imagine being a director and an officer of a company that's made up of nearly 1,000 members, and one day, unbeknownst to you, 2 members of the company walk into the office, approach an employee, tell that employee that they have a stack of documents in their hands that contain the signatures of enough members of the company to vote you out as your position as director and president of the company. They don't let the association see the documents. The company doesn't verify it, doesn't authenticate it. Instead, the company takes the word of these 2 members, removes you as an officer and as a director, locks the door so you can't come in, tells you you're out. Those 2 members take the petitions, they leave, you never see them again. They just disappear. You file suit in the lower court, and you're told that under no circumstances, as a matter of law, can you bring a cause of action against the members or the company for what just happened.
Well, that's not what the trial court did in this case. They didn't say now, as a matter of law, you couldn't bring it. What they said is that your allegations weren't sufficient in your complaint, right?
Your Honor, I would agree with that, but I believe the ultimate outcome, because 723.051, homeowners associations are governed by Chapter 720 and 617 of the Florida statutes. 723.051 provides that any member can bring a suit against any other member, against the association, for violations of the declarations, the articles, or the bylaws, the governing documents, and for violations of the statutes. And that's what my clients did. And in this, ultimately, at the end of the day, it's perhaps a little confusing how this case actually was removed. But in the beginning, the determination was that the first 9 counts of that complaint that alleged violations of Chapter 617, it alleged violations of Chapter 720, and alleged violations of the governing documents. The first ruling that we're talking about is June 20th, 2005.
Let me ask you to focus first on the mootness arguments in this case. As I understand, well, tell me if I understand correctly that given the terms of these offices and the times involved in this lawsuit, the terms of your clients would by now have expired regardless of whether or not they were removed. Is that accurate?
That is an argument, Your Honor, that enough time has gone by that there has been...
Wasn't whether it was an argument. Is that accurate?
Yes, intervening elections have occurred.
Right. So that if we were to remand this case, one of the remedies no longer available would be to put your clients back into their director seats, correct?
Arguably, yes, Your Honor. I can't say that I've ever seen a situation where once intervening elections have occurred that you could do that, but I've also not seen a case on point that says you can't.
Okay. Well, let's talk about those counts, if any, which survive in spite of that. As I understand it, one of your counts was seeking documents of the association, correct? And do I correctly understand that count, your clients were seeking documents in their role simply as members of the association? They did not have to be directors in order to get those documents.
That's right.
So that count would not be moot by what's occurred, correct?
That's right, Your Honor.
Have they ever been offered the documents up to this time?
No. The issue is of course, this is one of it's where we've kind of gone outside the scope of a motion to dismiss and really started looking at the merits of the case. But obviously the claim of the other side is that these documents don't have to be kept and aren't official records, and our claim is that they are and that they failed to provide them for inspection. But one of the fundamental...
Wasn't there a statutory change, though, that related directly to that in 2006 with regard to what records had to be kept and what records could be discarded?
Yes, there was.
And were the documents that you were seeking, and I take it those are the petitions that were supposedly signed by sufficient members for removal, was that type of document before 2006 the type that the law required that the association keep?
Yes.
So the 2006 amendment didn't make any difference in your estimation to that fact?
No, it did not. And the reason is I've dealt with a lot of association work, and I've actually taken a case up here before this court on a similar, under 617-0808, regarding the majority requirement to remove board members that have come up here. And the intent of those statutory changes, one was to provide an alternative, better means to address recall issues, which is what we're involved in, unfortunately, and occurred before that change, requiring those to now be arbitrated. And then basically the official records were broadened to just include essentially everything. And so that did occur, but that doesn't mean that these documents that allegedly removed my clients as directors of the company weren't official records that were required to be kept. And it's our position that both under the bylaws and under the statutes, there's one, the requirement that all minutes be maintained of membership action and meetings. And under 617-0701, which is one of the statutes that we filed suit under, it's required that if action is taken outside of a meeting, which is exactly what occurred here, under 617-0701, it states that any action that could be taken at a meeting, but it's taken outside the context of a meeting, has to be procedurally documented in a certain way.
And the action that you're talking about would have been the gathering of the signatures for removal?
That's right. And it requires that those documents be kept with the minutes of the membership meetings. So it actually requires those to be kept with the minutes, and therefore they become part of the official records. But even if you somehow feel that that does not require that the actual petitions be kept, it's still our position that under the written contract requirement of the association, that these are written agreements. There's been to some extent, there's been a big deal made out of the fact that, well, these are called written agreements as opposed to written consents. That's not the point of the statute. I mean, the point of the statute is there's one that's a procedure on what you do with these types of documents, and there's another one, 617-0808, which governs the voting requirements to take this type of action. Either way, though, even if you consider a written agreement something different than a written consent, it's an agreement. And
right. For a moment, going back to the mootness part, would that not apply to these documents as well? If your clients have now been would have been terminated from office by virtue of their term of office, why would they need to see the petitions now?
Well, because they have the right to, Your Honor. I mean, they're part of the official records. It really doesn't matter what the reasoning is. They can see those official records. If they're required to be kept, they can file suit for failure to keep the official
Any
records.
homeowner member could ask for them.
That's right.
And they don't have to give the reason they want them.
Not at all. And in fact, there's a 10-day requirement that they be made available for production. And there's statutory damages that flow from that. And in addition to all of this, we, of course, have relied on the Mazur case that was decided by this court on the exceptions to mootness. And if you read through the case, I think it applies to this situation. There is a collateral legal consequence that results from the dismissal of this case. It was, to the extent things occurred, that the statute has changed, that time has expired and intervening elections have occurred, they're at no fault of my clients that this occurred. And all of these causes of action have fee shifting.
Under the document count, you included a claim for your attorney's fees, is that correct?
Yes, Your Honor.
And under the statute, if you were entitled to the documents and you didn't get them, you get attorney's fees?
That's right.
Were there attorney's fee claims in any of your other counts that were dismissed?
Every account, every single one, has a fee shifting provision in it.
So, for example, the count which says they didn't properly carry out the recall process, you have right under the statute to attorney's fees if you prove they didn't carry out the process?
Yes, Your Honor. 723.051, which does allow a member to sue other members or the association, provides that the prevailing party in that litigation is entitled to their fees and costs. And that provision covers 720, which governs explicitly homeowners associations. And then in 720, they've carved out portions of 617, the Not-for-Profit Corporation Act, that applies to HOAs as well.
And the attorney fee order that's been entered against your clients at this point, is it pursuant to those same statutory provisions? Is that the basis that the fees are being awarded against your clients at this point?
Yes, Your Honor. There's been $100,000 in fees awarded as prevailing parties against my client.
Okay, let me talk to you a little bit about procedurally how this document count got disposed of. You filed a count that asked to see certain documents. Can you tell me, were the documents that you asked for all specific to the recall election, or did you ask for minutes generally or other kind of documents?
They included both.
Okay.
There were a number of actual written requests, which is the requirement under the statute. You make a written request to the association, but there was a requirement specifically to see these petitions, but then also to see any other documents related to this whole recall procedure and the removal of them as director.
If the records reflect that now somebody new was listed as a director,
Right.
Those kind of documents?
Right.
Okay. And the response you got to that from the other side was what? It couldn't have been, I don't have any, because that wouldn't be a motion to dismiss, right? They could have just answered and said, sorry, we don't have any. Now that count's been taken care of. So It was instead a motion to dismiss, right? What was the basis of the motion to dismiss their argument that these don't qualify as documents that the corporation keeps?
That's right. The association, and part of the problem we dealt with was the fact that you have two sides. We're entitled to sue members. We're entitled to sue the association for these various acts that occurred. And you have the association saying, well, we can't be held responsible for this. You got to look towards the members. You have the members saying, well, we can't be held, you can't seek any relief against us. This is association relief is the only thing that can be given. Then you have claims that everything's contradictory in the complaint because we're alleging things against both. The fact is they're both involved. Members and the association had to be involved in this process. The amendments that were made, explicitly recognize that, and that's not a new thing. That's just accepting the way these things have always worked.
Did you? Now we're talking about count 9 of the second amended complaint. I believe that's the one wherein you asserted your right to documents.
Yes.
And that the association was not forthcoming with those. Did you, in your request, because I don't have your complaint in front of me, did you assert that you had requested not only the documents associated with the recall, but also minutes and other documents as well?
Your Honor, it does. It is. Let's pull it up.
The reason I ask is because minutes are clearly referred to in the statute as to
I believe
items to which you would be entitled.
We asked specifically for the petition, but then also for other documents relating request to inspect all records, minutes, or documents. So
you did ask for minutes. Well, it seems to me you're clearly entitled to that, aren't you?
Can you read that again? You started to read it and I didn't hear it.
We requested to inspect all records, minutes, or documents of any kind used in the recall of plaintiffs dated January 7, 2004. That was the date of the request itself. There was a request to inspect official records dated December 22, 2003, and another one dated December 4, 2003. So, and that's a problem. And one of the things, no one moved to dismiss that count, and Judge in the lower court decided to dismiss it without comment. And one of the things that...
Sorry, there wasn't a motion to dismiss
No.
directed to count 9?
Never.
Was it answered? Was it ignored? What happened?
Well, actually, I take that back. I believe one of the two parties did move to dismiss count 9. The other one did not. When they filed
Was count 9 directed to both parties or only to one party?
That's the answer right there. It was directed only to the association, but the association did not move to dismiss it. So no
Association did not move to
They
dismiss
did not.
it?
They asked for an extension or enlargement of time to respond to count 9 and count 10, the deck action. I think the argument being that the results of the first 8 counts were going to determine what the response would be to those 2. And the court dismissed count 9, gave the enlargement of time on count 10. One of the things that's at least bothersome to me, because I've tried, to allege causes of action in this case and to follow the court's orders, is that, one, it's very difficult to get hearing time. So things dragged out. That's just the way it was. There's nothing you can do about that. But when the court issued its orders and these things were briefed, they were argued at length, things were discussed, I took the orders and followed them. I don't think there can be any argument that we did not comply with these orders. So a dismissal with prejudice, that second order of June 20th, 2005, where it dismissed counts 1 through 9 with prejudice, I'm just at a loss of how that can happen. We complied with the previous order. There were substantive grounds for dismissal, and there were technical grounds. The substantive grounds were grounds like, you can't do this, the association can't be a part of this, that it's a complete bar to bringing the claim. If that was the court's intention, yes.
What about their argument that, and I think they make the argument that your remedy was wrong, that the proper cause of action was maybe in quo warranto? What is your response to that? My response is clearly not. Amjur, one of the things that were cited, there's not a lot of cases that really deal with this, at least recently, but one thing that's clear with the quo warranto is that there can't be any other available remedy essentially at law. And 720 is very specific. It tells you exactly what cause of action you have. I've done them before. Are you essentially alleging that a public office is being exercised or held illegally? And if that's the case, is that what the relief in quo warranto is designed to afford?
This isn't a public office. So first, it's not a public office. It's a private corporation, and I do believe that quo warranto potentially could be used. It's an option, but again, there can't. The cases in State v. Bloodworth or Gibbs v. Bloodworth that has been cited in our brief says a writ will not be issued where there is another ample and sufficient remedy provided by law for the relief sought. 720 provides that remedy. It's been used. No one's used quo warranto to dispute a board position in a homeowner association.
Aren't there cases that use standard statutory remedies to do that?
Yes.
You're down to about 3.5 minutes if you want to save it for...
Yeah, I would like to save that. Thank you.
May it please the Court, my name is Mark Hildreth with the firm of Abel Band in Sarasota. I represent Appellee Continental Country Club. I have, by agreement with co-appellee, I would like to have 14 of the 20 minutes for my time, and then Mr. Russ would take the other 6 minutes, if that's acceptable to the Court.
Let's talk about count 9.
That's fine, Judge.
Question number 1, do you dispute opposing counsel's position that you never moved to dismiss that count and the court dismissed it anyway?
I don't disagree with that, Judge.
Does the trial court have the right to dismiss a count when the other side doesn't ask that it be dismissed?
I think they do under these circumstances, Judge, and let me tell you why I think that. The complaint that preceded that one, Judge Hallman entered an order on that the appellates have characterized as being technical and not substantive, and we disagree. We think the record shows, and particularly Judge Hallman's order, says that the court considered the contradictory and the negated allegations of our motion to dismiss the First Amendment complaint, and determined that those counts needed to be repled by the the plaintiffs in the case. And as we get into the motion to dismiss, we did ask for an enlargement of time, but what is important, I think the distinction here is that count 8, which was a count directed to the association, had to do with whether or not the records were official records, and then the count 9 was whether or not these official records had to be produced. And we had asked the trial court to enlarge our time to respond to count 9 because we felt, depending on what the court ruled with regard to count 8, that would be dispositive of count 9. Now, Judge Booth heard that. Judge Booth knocked out count 9 at the same hearing. We think, Judge, that at this point in time that can be covered by the Tipsy Coachman rule, that he did the right thing even though we didn't have that motion specifically pending, because subsumed within that decision was his determination under count 8 that these were not official records. And that's how we think we get to be okay on that, because it's not a matter of, as we go through this complaint, the plaintiffs kept adding facts or changing their legal theories. They kept doing the same thing over and over and over.
How does the removal of the director and the replacement of a new director reflect itself in any document?
That's a question I cannot answer for the court, because the way the statute was at the time, the 617-0808 says by vote or written agreement of the members. Appellants have taken the position that that has to be looked at as sort of a subset, if you will, of 617-07014, which we disputed to the trial court, and we would dispute here as well. And you raise a question I can't answer, though, because I don't know how that gets maintained, but it doesn't appear that...
Well, if we don't know how those documents are maintained, why is it an issue for motion to dismiss rather than ultimate for factual? I mean, if they say we want these records, they're records of the association, and your position is they're not official records of the association, why doesn't that require an evidentiary hearing to determine what we write, who writes it down, where it's kept, is it certified, is it sealed?
Fair question, except that the law, in effect, didn't specify that that would be an official record.
Well, did it specify it wouldn't be an official record, or does the statute simply say you, as a member, have access to any official records of the association?
Well, I think we have to start with what the statute said, 720.303, and it specifies the official records, this is subsection 4, what the official records were. And it doesn't say anything about recalls, and it also doesn't think about voting records. Now, forget recall for a minute, which is subject to 617.
How about minutes? Are minutes official records?
Minutes of meetings are official records, no question.
Do we know whether there were minutes of these meetings for recall?
It doesn't matter whether there were minutes of the meetings for recall, because they weren't official meetings of the association. That was our point at the trial court, that under the law in effect at the time, and the statutes have changed, and we don't disagree with that. But under the law that was in effect at the time, there was no legal obligation on the corporation. And I think this is a problem with the statute. It's not a matter of us trying to be hard-headed here necessarily, but it's a problem with the statute.
How does somebody who thinks that they were removed improperly because the proper methods weren't followed, or you didn't have sufficient petitions, or you didn't have sufficient signatures, what's their remedy?
Quo warranto.
That's the only remedy.
I think that is the only remedy under the law that existed at the time. The new statutes provide a whole new procedure for dealing with this.
All right, let's get past the procedure. Whatever method you go, whether you go by quo warranto or you go by another, what do you then have to allege, and what are you entitled to see to try and prove your case?
I think you're entitled to see whatever the people involved in the recall have. And let me tell you where this goes with that. In the in the complaints, one of the exhibits to the complaints was a document that the appellants attached that was signed by 19 different people. And it was a memo, if you will, to all the members that said, we want to recall these people, and it was signed by 19 different people. Well, I've always submitted that that would be the starting place. Those would be the initial defendants in a quo warranto, as would be the replacement directors who were put in, and perhaps my client, the association. Now, you file for the writ of quo warranto, and we discussed this in the trial court hearings. I'm not sure exactly what that pleading looks like, but between the things you can get on the computer and other things, you could cobble together a pleading. And we weren't going to necessarily oppose that. In fact, we submitted to the court at the very first instance that that was their proper remedy. So it wasn't like we were going to turn around and oppose that. But that would have been a way for these plaintiffs to get their matter in front of the court and have a judicial determination as to whether or not their removal was proper. The documents, apparently the documents, and we don't have the documents, we've not had the documents. Those were out amongst the people that effectuated the recall. But those documents would have presumably been available, and if they weren't have been available, maybe the plaintiffs would have won. But that isn't the issue that was presented to the court. The issue presented to the court was that there were alleged violations of the statutes and the bylaws, and the statutes and the bylaws didn't impose a legal duty on my client to maintain records regarding the recall. It's not required even to maintain records regarding votes, strangely enough, because the statute doesn't even say voting records are official records.
Did you argue to the trial court that, they were seeking an improper remedy and that quo warranto was the proper?
On every occasion we did, Judge. Our trial court memos are in this record. And
aren't there a bunch of cases since the 1925 case you cite where parties have used regular statutory methods, regular civil complaints to contest removals of directors?
Not under 720 and not under 617, Judge. We've looked at that thoroughly. There are no cases, and I don't even know if there's any under 607, because when we did the search under Quo Warranto, we found some cases from some other jurisdictions which were directly on point. We've cited them.
Are these public officials?
They are under the law in Florida, because the law of Quo Warranto is that because they are public in the sense that they derive their right from the state charter, and that makes them private. And the Gentry
Is that the same with corporations?
Excuse me, Your Honor?
Is that the same with corporations?
It is. And
if you wanted to remove the president of a corporation, is it your position that the only cause of action you could bring was Quo Warranto?
No, if the president was removed and wanted to challenge his removal, he would have to bring it under Quo Warranto, except under the new statute, under 720 now, if it was a homeowners association, there would be a mediation process. But at the time, there was not.
In count 9
Yes, sir.
of the second amended complaint, are there any documents or materials that are sought in that count that you think should have been given by the
I don't think so,
association?
Your Honor, because the way I recall the count, and I do have it here, but if I can get to it briefly, it's in paragraph 84, and it specifies the 3 things that they want, and they are things that relate to the recall. They save minutes, and Judge Palmer asked the question earlier to read the whole part of it. Inspect all records, minutes, or documents of any kind used in the recall. Well, there are no minutes used in the recall that were minutes as that term is defined in the statute.
How do we know that? Does somebody have to say that?
I'm sorry.
I mean, don't you get into the discovery part of it, and they say, give us all the minutes that relate to the, and you say there aren't any?
I understand your question. I think the answer is in the statute itself, is that if it relates to the recall and it's not an official act, it doesn't matter whether there were minutes or not. They could keep all the minutes they want, but if that's not an official meeting of the corporation and it's outside the scope, then it doesn't matter. That's our argument, and we think that's what...
Have you got case law or any authority that says that an association like this that derives its authority from a charter from the state necessarily is and those that hold offices in that association are necessarily public officials?
The only case we know of is the Gentry-Futch case from 1925. It's a Florida Supreme Court case that discusses generally Quo Warranto. And it's a private corporation case. It's not a public officer case. But it does address that in the case of a private corporation, and I don't know why there would be a distinction between a profit and a non-profit, but in the case of a private corporation, Quo Warranto is the way to, quote, try title to...
Yeah, but do you have a case, a specific case that says in an association like this that officers of this association... I mean, the association is not open to anybody in the public that wants to come and join, is it?
No, but neither is a private corporation.
Well, but still, do you have any cases or any authority that says in an association similar to this, simply because it derives its authority from a charter issued by the state, that those people that hold offices in that association are necessarily public officials?
Oh, we don't, Your Honor. We don't think that's the question. We think the question is under Gentry-Futch, a Florida Supreme Court case that says Quo Warranto applies in cases of private corporations when you try title to an office. We think that's where it derives from. That case has never been challenged. There are no new cases.
Was there, at the time that case was decided, was there any statutory mechanism in place relating to removing officers?
I don't know the answer to the question, Your Honor.
Isn't one of the things that case says is you use Quo Warranto only in the absence of other available remedies? It's the only available remedy?
If it's the only available remedy.
If there is a statute which provides a mechanism, wouldn't that take the place, and therefore you could bring a statutory action because now Quo Warranto isn't the only available remedy?
I think that if there was such a statute, I just haven't seen the statute in this case, and that's what I point to.
Don't we have a statute here that defines how you recall somebody?
It says, yes, 617-0808 says by a written agreement.
And if somebody violates that statute, why don't you have a cause of action tied to the violation of that statute as opposed to a Quo Warranto action?
Your Honor, I don't think that the statute gives that right of action. In 720.305...
Could another member of the homeowners association file an action to challenge the removal and the insertion of the new directors? Not because they want the office back, but because as a homeowner, they think the improper method was used to remove an officer and put somebody else in?
I think they have to use quo warranto under the way the law reads. I don't think 720.
Can they do that if they're not seeking to get the title?
I think they may be able to. I don't see why not. I've not looked at the standing question under quo warranto if you have to have the standing. I mean, logically, it would make sense that the person who has the right to the office would be the first person to bring it, but under a corporation, there's nothing that would prohibit, I don't think, another party in interest, if you will, or a member or shareholder from doing that.
Getting back to count 9, I think you can see that you filed no motion directed to that count to dismiss, but you did file a request for some additional time to respond or file appropriate motions. Is that essentially what you did? You wanted additional time to take a look at it and to come up with a defense or a motion directed to it?
That is what we did, Your Honor.
And then am I understanding your argument that the trial court said that's not necessary because I'm going to dismiss it anyway?
I think that's a fair characterization.
Is there any authority that you can present to us that allows a trial court to simply pick out a count in a complaint where no motion is directed to that count and just dismiss it on its own?
I can't give the court that authority, but I can say this that I think addresses the issue. The issue is that the same substance of that claim in count 9 was repeated later on in the third amended complaint with regard to the issue of producing or maintaining the so-called official records. And ultimately, Judge Hallman made a determination that based on the entire sequence of events, including the fact that the claims kept being pled over and over and over again, that they were subject to dismissal because there was no statutory rights to the relief requested based on the facts that were alleged. The trial court, I mean, we had the same trial, we had a trial court consider this substantively 3 times on 4 different, because the first pleading was amended without court order. But then we get to the point where Judge Hallman makes, I think, a substantive ruling on the amended complaint. Judge Booth makes a ruling on the second amended complaint that deals with count 9. It gets to Judge Hallman again with all the same things. If they had alleged some different things, I think there may be, I would have a harder time with your argument or your question to me. But when we get to the last count, Judge Hallman still had the benefit of looking at all the prior rulings, and he can make whatever decisions to pick and choose on those that he needed to, but the substance of the claim remains the same.
If you don't timely move to dismiss, don't you basically waive your procedural right to do that? And if you don't timely move to dismiss and you waive that right, does that then give the trial court the right to go and on its own pick out a count and dismiss it, even though there's no motion directed to it?
I think when the count gets dismissed by the trial court, as happened here, then it doesn't exist anymore.
I know, but what authority? I guess I'm asking you, if you have to file a motion to dismiss. If you don't file your motion to dismiss and it's not timely, you essentially waive that, don't you? You waive your right to file the dismissal.
But we moved to enlarge. There was no question about that.
So you're saying that your motion to enlarge preserved your right to file a motion to dismiss later?
I do think that would be the case.
All right.
We're down to 5 minutes.
I'm sorry. I need to
Could a trial court just dismiss an entire complaint without any motion at all?
I don't think so.
Well, then why can the court dismiss a particular count of a complaint without any motion?
I understand the question. I think it gets remedied, though, in the way that the plaintiffs responded subsequently when they filed their third amended complaint and left the same claim, and it was dismissed ultimately by Judge Hall. So it was addressed by the court. Thank you, Your Honors.
Your Honors, my name is George Russ, and I am with the firm of Sellos, Russ, Saylor & Johnson, PA, in Leesburg, Florida. I represent the 2 individual defendants in this case, Ray Bordato and Joan Dewey. To the extent that the arguments of counsel, Mr. Hildreth, applied in my case and the individuals, I will not attempt to repeat those arguments.
Have you asserted a mootness issue in this case?
Yes, sir.
How do you respond to opposing counsel's argument that they included claims for attorney's fees in all of their counts, and therefore the counts couldn't have been mooted out by the fact that they could no longer assume those directorships?
I'm not sure I understand your question.
I understand their position is that on all of the counts that were ultimately dismissed, they had claims for attorney's fees. Normally, if you had a claim for an attorney fee, even if by passage of time you can no longer get the primary relief you wanted, i.e. get your seat back on the board, you would still have a right to assert that because of the violation of the statute, I was entitled to attorney's fees, and therefore those counts would not be moot.
Well, in light of the fact that the court ultimately dismissed the second and third complaint with prejudice, I think they would no longer have a right to attorney's fees. I would think that
if the dismissal is correct, but not simply because of moot, correct?
But that there wasn't really a cause of action for attorney's fees. It was a request for attorney's fees if they were prevailing parties in the action. Did I answer your question?
I think so.
Okay. I think the distinction here in my client and the corporation is the majority of the allegations against the individual clients appear to center around irregularities in the process of the recall. I think it's significant to note that in the original complaints, the plaintiffs included documents as exhibits, I think it was C, D, and E, that purported to be documents that had to do with this recall. And ultimately, it was determined that those documents didn't make any reference to my clients. In fact, one of the documents, which was the letter that purportedly sent out the petitions, and the petition for recall was also included in that original complaint, did not in any way relate or mention or talk about Ray Gordato or Joan Dewey. So they didn't name any of the people that did sign the recall letter as defendants in the lawsuit. They named only Joan Dewey and Ray Gordato, neither one of which signed the letter and disseminated the petition. They later withdrew that. It wasn't in the later complaints. And I would argue, Your Honors, that if that is relevant, it should have been attached even to the later complaints. And if it was not relevant, and I'm suggesting that's why it was deleted against my clients, then they should have included it pursuant to the rules of civil procedure. The allegations against my clients seem to center around wrongdoing primarily to the extent that they committed some type of fraudulent activity. And it's virtually devoid of any specific factual allegations.
Well, if the argument is simply they didn't comply with the requirements, they didn't get enough signatures, for example, that wouldn't have to be a fraud count, right? That could just be an alleged statutory violation. If that's the case, who's their cause of action against? If they want to complain because somebody's removed them without getting enough signatures, for example, is their cause of action against the people who collected the signatures, or is it against the homeowners association?
I suppose you could bring an action against both. In that, for the not getting enough signatures, I suppose not against the corporation because they were not involved in that process. There was a meeting held that was billed as an unofficial meeting. They quote this same document. They quote this notice. Again, that's one of the documents that was taken off their later complaints, which they don't attach later, but they quote it. So it needed to be attached to the complaint. But, yes, I think they could have a cause of action against the defendants to the extent of not getting the signatures. And I mean, they've made claims against the corporation for not properly documenting it and having records to that effect.
Are you saying that if it were required, let's say, just to choose a number, that 50 signatures were required as a minimum, and that your clients brought a petition that contained only 48 signatures and asked that action be taken on it, that they're subject to a lawsuit for not having the two extra signatures?
Well, their allegation is that my clients misrepresented that to the corporation. That they, in fact, they say they did not get the signatures. My client don't say they didn't even head up this group for that matter, but that's neither here nor there. We're going from the complaint.
Yes.
My clients, they say, number one, went about forming a committee, an unofficial committee, got these documents signed, and then presented them to the corporation, but there weren't sufficient numbers. They give no specific facts underlying those allegations. They're just mere conclusory statements. There's not a single fact alleged that I'm aware of in any of the complaints at any time or any of the counts that give any basis for that whatsoever. and they say they don't have the record.
I wondered about that because I read that argument in your brief, and my question is, what do they have to allege? If they allege they didn't collect enough signatures, or they didn't collect the signatures properly, they didn't collect them enough, what more do they have to do for pleading purposes? You say they don't verify how they know that. Why is that not a discovery issue, not a pleading?
Your Honor, they admit, and this is another document they didn't attach to their complaints, they admit that there was a meeting. They admit that it was noticed. They admit the notice said that it was not an official meeting. When the meeting was held, that's where the breakdown comes. They say, well, where are the documents? Well, in fact, and it's not apparent in the record because they never attached it to their complaint, but there was delivered to them the minutes of that meeting along with the tabulations, and they were able to be at that meeting contrary to their allegations and had indicated intent.
Wait a minute. They allege they weren't allowed to be at the meeting. That's all we have on the record.
Well,
you can't, for purposes
that's
of
true. They allege that, but
yes, that's a lie. They could have been here. We've got to take that allegation as true, don't we?
Well, not with regard to my clients, because even if the allegation were true, as they said, with regard to my clients, I can't speak for the corporation. But with regard to my clients, I say my clients told them they couldn't be there. Well, number one, if it's an unofficial meeting, my clients can't tell them, even if they said they can't be there, they could be there. I mean, my clients had no authority whatsoever to keep them out of that meeting, and they knew that. And in fact, after that, they indicate in one of the emails that they, in fact, intended to be at that meeting, even after they supposedly were told they couldn't be there. I don't know why they didn't show up, if they didn't show up. I don't even know that. My clients did what they were required to do, if they did anything. My clients, first of all, don't acknowledge at any time heading up any committee, and that's evidenced with the documents as well. So they wanted to get documents from my client too. My client said, well, we don't have those records. We never have had those records. I've never had those records. And the court said, well, if you don't have them, you can't produce them.
Okay, you're way over your time. So I'm going to stop here.
Thank you, Your Honor.
Counsel.
Your Honor, just a few follow-up. First of all, as far as the individual defendants are concerned, I think if you look through their motions to dismiss and their arguments made throughout the course of this, that they essentially amount to denials, which I think is improper on a motion to dismiss. But getting past that, there's been the argument that we've pled over and over the same things, and that's because it's always been one simple issue. The 617-0808, which governs how many votes are required to actually do a removal, that was one of the provisions that we filed suit under. 617-0701 subsection 4 has to do with what do you do with those once you have them, do they have to be filed? It's very clear. Any action that can be taken by the members outside of a meeting has to be done in a special way. Those have to be evidenced by a written document. They have to be given to the corporation. There has to be a notice provided to all the members 10 days after the corporation accepts the document, and those things did not occur. That's what we've alleged.
How do you respond to the allegation that a meeting called to remove a director is not a, quote, official meeting?
I think it's impossible. First of all, if you have a special meeting, the requirements under 720 is that the only people that can call that special meeting of the members is the association itself. It has to be called either by the president or the vice president. They can do it by themselves, or if a majority or a certain percentage, I think it's 10 to 15% of the members, sign a petition to have a meeting, then the president has an obligation to call a special meeting. So if there's two ways to do a removal, it's either by vote at a meeting or by agreement. Well, it's clear if it's by vote that the association's involved. They have to call the meeting that the vote actually occurs at, and there's going to be minutes. And if it's by agreement, it makes sense that the association's involved when you look at 617-0701 and 617-0808.
How does the removal actually take place? Is there a document that's prepared that's a notice of removal or a notice of votes or something that creates the act which results in this director no longer being a director? Is that in the pleadings?
I've dealt with a lot of removal cases, and you asked for a case, South Chase Parcel 45 Community Association versus Stephen Clooney et al. I was in that case. That was a removal case on 617-0808 that was before this court. That's an example, but the way it occurs is either you have the meeting and there will be people actually raising their hands and voting, and somebody documents that, the secretary, and you have
And
minutes of the
presumably
meeting.
something shows up in the corporate documents to show who is or isn't a director, right? If
Always.
nothing else, a list of who the directors now are.
That's right. And if you look at the revisions to 720, there's now in the Department of Business Professional Regulations that has a division of condominiums and homeowner associations, they have a petition that they recommend that you use that lays out specific information. Yes, that's all occurred after the fact, but that doesn't change that you still had these obligations to have these written consents and documents that evidence this action. This is a huge association. I've been involved in associations with 100 people and you can't get 10% to do anything. And here we're talking 700-800 people, and over half of them voted to remove my clients. I think you need to see the documents and make sure it's correct. And they just disappear. No one knows where they're at. We've alleged that the two individual defendants were responsible for that. They can't just deny it. I mean, that's our allegation. We have a chance to go prove that. The fact is, they were the two responsible. That's what our allegation is. But, there was a reference in the one order that said there was some...
Excuse me, but they were the two responsible for what exactly?
For this recall, for gathering the names.
You mean they walked around and had people sign a petition?
Yeah, I'm sure they had other help. But see, the documents they're referring to that were attached to the first complaint, they're anonymous. So there's, again, these are our allegations. I can go into why, and I can go into even some depositions that occurred after, but that's not proper. But the fact is, these were the two involved. And they're members, and under 720, again, members can sue other members or the association, and members also under 720 are required to comply with all the provisions. And so they have a requirement to do that. They can't go around, act like they did a recall, and if it's incorrect, just be held unresponsible for that. So I wanted to state that 720 was amended, and I wanted to just quickly address this because it's almost as if there's this argument that in 2006 it was amended for the first time ever, now we have recalls. That's not the case. Before then, there were recall provisions of 720. The thing that's changed is now you have to go up to arbitration before the DBPR. And now the official records are more clear on what they include under 720. But the provisions regarding recalls were in there prior to that. 720 had, you got to have a majority removal, 617, 08, 08. Those were all in existence. And so under 720, we have the right to sue the association or members if they violate that provision, and that's what we've done. We sued that. Every single count had a fee shift provision in it, and that's the collateral legal consequence that comes about from this dismissal. And the case can either be determined as moot, and that's how it was disposed of. And if it was moot, we had the collateral. We argued it wasn't moot, but we weren't responsible for why it was determined to be moot. Or, as they argued, that what really happened is the first 9 counts were dismissed with prejudice, and then part of the basis for that final order, in addition to mootness, was, well, I've already dismissed the other 9 counts. If they're with prejudice, the same fundamental concepts can't be the basis for a DEC action.
Okay, thank you, Counsel.
Yes, thank you.
We're over as well. Thank you.